Ready, start. She, however, stated that while filing its claim, the insured had included the cost of sample pieces. She contended that the insured relied on the generalized findings of Messrs. Aura pertaining to furniture, fittings, building, plant and machinery, showroom and electrical fittings without any evidence to substantiate their findings, and Messrs. Tarun Gandhi for stocks without substantiating the basis or proof of their analysis, and hence both were unreliable and could not be a piece of evidence to contradict the detailed report of the final surveyor. She stated that the insured had attached a table of cancellation of orders and divided the claim of rupees 2 crore 65 lakh 75,647 into rupees 1 crore 72 lakh 88,452 as against cancelled orders, rupees 50 lakh 2,698 as against accessories, and rupees 42 lakh 84,497 as against samples. She contended that this table had been created by the insured with the assumption that all its products were finished products. However, it cannot be accepted when it is not supported with evidence. She emphasized that cancellation of orders does not prove actual loss. She submitted that the insured claimed that they had provided documents which constituted 5,855 within bracket in words 5,855 bracket close pages. However, except the final surveyor, no one else had perused the documents in detail and conducted a proper physical inspection of the premises. The insured had not filed even a single document before the National Commission or before this court to show the exact number of units damaged slash burnt, whether they were finished products or WIP or raw material etc., and what were the corresponding rates of each item. Hence, according to her, the insured, being the complainant, had failed to file base documents and discharge the onus of proof. A consumer forum which is primarily concerned with an allegation of deficiency in service cannot subject the surveyor's report to forensic examination of its anatomy, just as a civil court could do. Once it is found that there was no inadequacy in the quality, nature, and manner of performance of the duties and responsibilities of the surveyor in a manner prescribed by the regulations as to their code of conduct, and once it is found that the report is not based on ad hocism or vitiated by arbitrariness, then the jurisdiction of the consumer forum to go further would stop. There is no difference between a contract of insurance and any other contract except that in a contract of insurance there is a requirement of good faith on the part of the insured, and the contract is likely to be construed contra proferentis, that is, against the company in case of ambiguity or doubt. It was further held in the said judgment that the duty of the court is to interpret the words in which the contract is expressed by the parties, and it is not for the court to make a new contract, however reasonable. She contended that the final surveyor, while concluding his report dated 30th March 2011, despite calculating net assessed losses for all claims, had erroneously directed payment of gross loss amounting to rupees 61 lakh 39,539